It's impossible. The D.C. federal judge knows that. Special counsel Jack Smith knows that, and soon you will too. But first, some background. Consider two numbers, 12.5 million and 189. Now, divide that 12.5 million by 189. 12.5 million is, by the way, is the number of documents the government is turning over to Trump's lawyers for trial. 189 is the number of days before Trump's trial date of March 4th. That was set today in the January 6th case by the federal judge here in D.C. Actually, don't bother to do the math. I already did it for you. 12.5 million divided by 189 is 66,137. That's an important number. That is the number of pages each day Trump's lawyer must read between now and March 4th if he wants to be ready for trial. He is to read all of them. Some maybe he can skim, but he has to go through each of them. Any lawyer worth his salt and wanting to comply with the right to counsel clause in the Constitution goes through every single document produced by the government. That number, 66,135 a day, is, of course, absurd. No one can do that. And it's made all the more absurd when you consider that it includes reading 66,135 documents on Thanksgiving, Christmas, New Year's, Martin Luther King holiday, President's Day, and all the weekends. And what that number doesn't even take into account is other work that must be done in preparation for trial. Meeting one's obligation to render effective assistance of counsel is serious. Getting ready for trial means witness conferences, investigating, witness interviews, hiring experts, expert witness conferences, including in this case meeting with audio and video experts who must pore over all the videotapes that this prosecution has in its custody. The videos, they have to be inspected and scrutinized for any unfair or sneaky edits or for any evidence that might be favorable to the defense. I don't know how many hours of video the prosecution has, but I can make a good guess. Because in February of this year, Speaker Kevin McCarthy turned over to Fox News 44,000 hours of security video from January 6th. I make the assumption the prosecution has the same security video as Speaker McCarthy, 44,000 hours worth. I did the math for you again. To watch 44,000 hours of video in 189 days, the number of days until trial, would mean watching 232 hours a day. Of course, that's ridiculous. The day only has 24 hours in it. So tell me, how does the judge think that will happen? And in considering these numbers, this demand on the defense counsel, I did not factor in such things as eating and sleeping. In short, reading all these documents, watching all these videos to get ready for trial in the next 189 days is not nearly impossible. It is impossible. The special prosecutor is so well aware of this. By the way, he asked for a trial in January, 2 months earlier than March 4th. What does that tell you? No lawyer under these circumstances can render effective assistance of counsel. By the way, I gave you the best case scenario. What if real life also gets in the way between now and March 4th? What if the lawyer or family member gets COVID, even for 5 days? It's going around again. You might have had it recently. By the way, I don't understand this federal judge doing this, setting a date where it's guaranteed Trump's lawyers can't render effective assistance of counsel. She was a public defender. She knows exactly what she's doing. She also can do the math. As for special counsel Jack Smith, I assume he can do math too. My guess, the judge and special counsel Jack Smith will now try to cover what they're doing. They will both say Trump has money. He can hire more than one lawyer. Please do not fall for that. That's a ruse. No good lawyer rendering effective assistance of counsel, even with a very able co-counsel, would ever go to trial without reading every document, watching every video himself or herself. Which brings me to this. Trump's lawyer, in light of the fact that he's in an impossible position that the judge has put him in, should withdraw from the case. No lawyer can render effective assistance of counsel under these circumstances. He should withdraw. And a note to the judge. There's no urgency to try this case on March 4th. Really? And in selecting March 4th, she cited a public interest in getting this case to trial. But guess what? That's not in the Constitution. If she thinks it is, she needs to reread the Constitution. Right to counsel, though, is in the Constitution. It's Amendment 6, right after 5, if she needs help finding it. And the Supreme Court has said not just any lawyer satisfy the right to counsel, but effective assistance of counsel. I don't know whether Trump is guilty or not. I will wait for trial. But in the meantime, Trump has constitutional rights. This is not a game. There was also action today in Georgia state and federal courts. Today, the Fulton County Court set September 6th for the arraignment of former President Donald Trump and 18 other co-defendants on the Fani Willis indictment. It is expected that each defendant will enter a plea of not guilty for alleged emphasis on alleged efforts to overturn the 2020 election in Georgia. And today, in a Georgia federal court in Atlanta, former White House Chief of Staff Mark Meadows took the stand. He asked U.S. District Court Judge Stephen Jones to remove his case from Fulton County Court to the federal court. We're awaiting Judge Jones's decision. Good evening. I'm Greta Van Susteren. This is The Record. Congressional Correspondent Kilmeny Duchardt was at the courthouse in Washington, D.C. today, where U.S. District Court Judge Tanya Chutkan set that March 4th trial date. She joins me. Kilmeny, I wanted to find a little local color because there's nothing like being there. So were you in the overflow room at the courthouse for the media?
The media room, exactly, where you have 3 different video feeds, one that's on Judge Chutkan, one on the prosecution, and one on the defense. So you can really see the back and forth that ensues. And Greta, you made an amazing opening argument here for what really the defense had tried to do in court today, arguing why this case needed the time that it needed. Now, Judge Chutkan, in her preamble, led just about anyone to believe that she would not be siding with the defense's proposal. She cited a number of Supreme Court cases, saying that she had not identified any cases that have been given more than 2 years. She talked about how,
But that's sort of the insanity of it. It's not whether there are other cases. There is no case like this. The question is very fundamental, and that is the Constitution. And you've got to let a defendant to have effective assistance of counsel. That's not a maybe. That's not a sometimes. It's not anything. It's right there. And if you don't give the person, the defendant, the opportunity to have his lawyer prepare. And by the way, I said it was 12.5 million documents. It's actually 12.8 documents. Yeah. And so to me, it's so obscene. Why wouldn't you want him to have a fair shot at this?
Right. So after that, after she goes into her arguments of why this, again, should be accelerated on some level, she then has an almost 20-minute back and forth with John Laura, one of Trump's main defense attorneys in this case. And you can see the frustration on his face, already knowing that Judge Chutkan's mind is probably already made up, but trying to make a lot of the arguments that you did in your opening monologue, that this is an incredible amount of evidence. And at one point, Chutkan says, some of this material is not new to you. And she said, and he says, yes, it is. He's essentially saying the clock should start on our defense team having to go through this at the time of the charge, not beforehand, which is what the prosecution's argued. Well,
but I mean, it's almost silly because you need to know the universe of materials that the prosecution is going to use against you. It doesn't matter if it's someplace out in the public sphere somehow. That's just absurd. But tell me, was the courtroom packed? Could you tell whether it was packed or not?
Yeah, Greta, not as much today because there was not a required appearance from the former president. So I imagine when this gets underway on March 4th, which, to note for our viewers, this is the day before Super Tuesday when a large majority of states had to make their decision in the presidential primary. So it's absolutely going to affect the campaign. We can expect that courtroom to be a lot more full, to have a much larger media presence as we did during opening arguments.
Kilmeny Duchardt, thank you.
Thanks, Greta.
Criminal defense attorney David Markus and criminal defense attorney Jeff Brown joins me. Both very capable defense attorneys. So let me go first to you, Jeff. Could you be ready for trial to read 12.8 documents and 44,000 hours of video between now and March 4th?
No, that's absurd. The amount of documents that I'd have to look through. And of course, I want to look through them. It's another story about who's going to present them in trial and cross-examine. You may have second chair, but I want to look at every document. I'm responsible to my client ethically to look at every document, to find things that help us, that hurt us, that tie into other evidence. There's no way I could be ready for trial like that. But here's the part that really, really bothers me, and what people need to know is this is unheard of, at least in my practice. I have never, ever in 30 years had a judge force me to go to trial when I wasn't ready and telling the judge I wasn't ready. Now, they may push me and prod me to get ready, but at the end of the day, I've never had a judge that wanted me to go to trial without me saying, yes, judge, I'm prepared to go to trial.
David, 2 questions to you. Could you be prepared for trial? 12.8 documents, 12.8 million documents, 44,000 of videos between now and March 4th. And let me add this, is that if you couldn't, would you withdraw from representing the president or any client knowing you couldn't be ready?
Well, Greta, it's impossible, of course, to be ready. I agree. And it used to be in the old days, we would all complain that we wouldn't get enough discovery. We wouldn't get enough evidence. We wouldn't get enough materials to prepare. That was typically the complaint for many, many years. Now the government has a different tactic. They dump so many documents, so many videos, so many things on us that it's really hard to get ready quickly. And 95% of what they give us is immaterial. But you're right. We still need to go through it to be prepared. And so what the government used to do is wrong. What it's doing now is wrong. Whether I would quit the case, I met with President Trump and did not take on the documents case here in South Florida because of what you say. I knew what was going to happen. I would have to shut down my practice, and I wasn't prepared to do that. I have other cases. I have a life, and these judges are going to be unreasonable in terms of getting ready quickly. So it's putting lawyers in an impossible position.
Jeff, can you ever be effective as consistent with the Constitution if you can't be ready?
No, you can't. I mean, that's the basis of the Sixth Amendment. You're entitled to the lawyer of your choice, and you're entitled to have a lawyer that's effective in representing you. And this is literally impossible. And it bothers me that the judge should know or doesn't know better than this. I mean, as you just did the math, it's just shocking to me that she's pushing this trial for the day before Super Tuesday and then wants to argue that this isn't political. This is clearly political because, as she should well know, and as David was talking about, you can't represent your client without going through this evidence. And it's impossible to ask me to spend every living or waking, breathing moment on this planet from now till March 4th going over evidence. I mean, there's so many other things that are going to come up in your lifetime. In fact, I guarantee you there'll be more discovery dumped on them. This is the first production. There'll be more production. There'll be more discovery documents dumped on them before you get to March 4th.
David, I find it also notable is that the prosecution, I mean, they know what they're dumping on the defense. I mean, this is no big secret. I mean, what we're telling the viewers right now is anyone who practices law when the prosecuting defense knows exactly what's going on. This judge, who was a public defender, knows exactly. But the idea that he wanted this trial in January, even 2 months earlier, I mean, it's impossible for March 4th. But can you justify anything the special prosecutor is doing in this by wanting it even in January?
Well, the prosecutors, remember, have been investigating for years and years. So should the defense have an equal amount of time? Maybe they should have more time. It's his life and liberty at stake. But to say January, I mean, the prosecutors, that was totally disingenuous for them to come forward and do that. Judge Chutkan actually is a very good judge. I'm surprised she did this in March. I have to say, she's typically very, very good. This was obviously a mistake. Now, I don't think the trial is going to still go in March. What's going to happen is Trump's going to file a motion to dismiss for immunity. And when that's denied, he can appeal it to the D.C. Circuit and all the way to the Supreme Court. So I doubt that March date is going to stick, and it shouldn't stick, of course.
I think it's unconscionable for any lawyer to take this case if you can't do it effectively, because you're basically lying. And looking at those numbers, I don't think anyone can effectively do it. So I don't know how Trump gets any lawyer, because I think these lawyers should remove themselves, number one, because they can't effectively do it. And I don't know who steps in, because every day that advances, it gets even demonstrably worse. But I'm taking the last word on that. David, Markus, Jeff Brown, thank you both.